In China, the foreign-related rule of law is a key concept used with the domestic rule of law. Foreign-related rule of law has been emphasized on many occasions. Above all, this concept is remarkable and contributory in terms of promoting the birth of many new laws like the Immunities Act, also promote the revision of some old laws like the Civil Procedural Law. Actions have been taken by China's legislature, the judiciary, and the administrative to put into practice the concept of foreign-related rule of law. Some laws have been passed and amended accordingly. So these laws include the Immunities Act and the Civil Procedure Law. Actually, on the same day of September the 1st, 2023, China passed the Foreign State Immunities Act, the latest revision of Civil Procedure Law. The former entitled Chinese courts to hear the immunity exception cases for the first time and heralded the adoption of the restrictive immunity by China in a sharp contrast to the past absolute immunity as doctrine. While the latter, the Civil Procedure Law, fundamentally updates China's international procedural rules for the first time since the passing of the law in 1991 by introducing a number of new rules for international litigation, including rules on jurisdiction and the service of process. Without any doubt, both laws marked a fundamental breakthrough in China. It is fairly certain that more of such laws will follow, alongside the deepening foreign-related rules. The following question is how such laws are connected or coordinated, especially with regard to the Immunities Act and the Civil Procedure Law, because both laws address a core issue, the jurisdiction of Chinese courts. Just as the question I posed at the beginning, is it necessary to coordinate the operation of the laws? The answer should be yes. There is large room for the Immunities Act and the Civil Procedural Law to collaborate with each other or coordinate each other. Both laws are in essence related to international litigation, and they both address such matters and jurisdiction, service, and so on. They are significant by themselves. Nevertheless, they are closely connected in a coordinative manner. Just as the both laws state, they mean a lot to each other. For example, Article 16 of the Immunities Act states that where this law is silent, the trial and the enforcement procedures for civil cases involving foreign states and their property shall be governed by the Civil Procedure Law and other applicable laws of China. And also, you will refer to the new version of the Civil Procedure Law, Article 305. It states that the provisions of laws of China on foreign state immunity shall apply to civil cases involving foreign states. If the relevant law is silent, this law shall apply. We clearly see that both laws state that they will rely on each other. If we focus on the Immunities Act, the conclusion will be that the Immunity Act is not self-sufficient. I would like to list 5 points for illustration. First, the Immunity Act does not contain the venue rules for establishing, finally pinpoint the Chinese court for exercise of jurisdiction. Second, the specific jurisdiction of the Civil Procedure Law may be cited by Chinese court to hear some immunity exception cases. Third, reference to the Civil Procedure Law and other laws is necessary for such issues and service of foreign states. Fourth, the enforcement of rules of the Civil Procedure Law may be referred at the enforcement stage, just as the Immunity Act states explicitly. What's more, the Immunities Act will mostly be applied by Chinese courts. This will make the judicial interpretation of the Immunities Act indispensable. So the past experience or rules regulating the same or similar jurisdiction grounds under the civil procedural or other laws by the Chinese courts are understandably involved. So based on the above preliminary observation, I now turn to show you how the jurisdiction rules of the two laws interact with each other. First, the two laws have some common grounds of jurisdiction, as well as some difference, of course. Second, the civil procedure law has more heads of jurisdiction, and it also has rules on regulating parallel proceedings, which are not seen in the Immunities Act. For example, both laws contain such heads of jurisdiction as forum selection, appearance for defense on the merits, place of performance of contracts, place of harm, place of immovables. Now let's select some of the key grounds of jurisdiction for comparison. If we cast a closer eye on these common grounds, we may find the similarities as well as some commonalities of the two laws. For example, Article 4 of the Immunities Act states that a foreign state shall not enjoy immunity if there is a written agreement. And if we turn our eye on Article 277 of the Civil Procedure Law, it also has more or less the same provision. That is, the chosen people's court shall have jurisdiction. Right? So these two rules are intrinsically the same in setting forth the jurisdiction based on the parties' autonomy. So the next ground of jurisdiction for comparison is Article 5 of the Immunities Act. Article 5 of the Immunity Act states that under any of the following circumstances, that is, if a foreign state participates in a proceeding instituted against it or by a counterclaim, or then the Chinese courts may acquire the jurisdiction. And Article 278 of the Civil Procedure Law explicitly states that where a party raises no objection to jurisdiction and responds to action by submitting a written statement or by a counterclaim, Chinese court shall acquire jurisdiction. The requirements, as I observe, are the same under the two laws for the jurisdiction based on appearance before courts or defense on the merits of a case. In fact, we may find more of such commonalities or similarities in designing the jurisdiction grounds. Anyhow, the two core grounds of jurisdiction just analyzed will illustrate the same or similar part of the two laws in designing international jurisdiction. A further closer comparison of the two laws may reveal that the civil procedure law contains much more heads of jurisdiction than the Immunities Act. The heads of jurisdiction of the civil procedure law may further provide for the venue for specific international litigation involving foreign states. I would like to mention a special provision under the civil procedure law, which is very unique. That is Article 276. It says that where an action for foreign-related civil dispute is brought, the People's Court and the place where the contract is signed or performed, where the subject matter of the action is located, where the impoundable property is located, where the tort is committed, or where the domicile of the representative office is located, may have jurisdiction over the action. And it also has a second paragraph. It is a very broad ground of jurisdiction. It says that if a foreign-related civil dispute has other appropriate connection with China, the Chinese courts may have jurisdiction. This is a very broad ground of jurisdiction under the civil procedure law. It may be argued that the Chinese courts and the place where the contract is signed or formed, where the subject matter of the action is located, where the impoundable property is located, where the tort is commit or where there is any such kind of appropriate connection. When the foreign state is involved, Chinese court may acquire the necessary jurisdiction. And difficulties may occur in the case of applying the exclusive jurisdiction stipulated under civil procedure law. We have now seen the updated list of exclusive jurisdiction for international litigation under the civil procedure law. The civil procedure law lists 3 grounds of exclusive jurisdiction concerning the formation, dissolution, or liquidation of a legal person or any other organization in China, intellectual property and performance of a contract in China, which involves a Chinese corporation with foreign investment. The Immunities Act allows Chinese courts to exercise jurisdiction against foreign states in the case of intellectual property interests, just as the professor in the previous talk showed, but not of other circumstances of exclusive jurisdiction prescribed by the civil procedure law. Is it to mean that when a foreign state is involved in the cases like those concerning for performance of a contract in China, which involves a Chinese corporation with foreign investment, Chinese courts can't exercise jurisdiction, even though the relevant foreign state act is deemed commercial? The answer, in my observation, should be no. If a foreign state act is deemed commercial, such exclusive jurisdiction grounds shall apply with priority. Now, if we turn our eyes on the newly amended civil procedure law, we may have some new findings. Okay, the civil procedure explicitly sets forth the mechanism for regulating jurisdiction between China and foreign countries, and I think that these 2 mechanisms for regulating the parallel proceedings may also apply in the cases of Immunities Act. The above analysis reveals that the Immunities Act and the Civil Procedure Law both address the international jurisdiction of Chinese courts as their core aims. We may call the Immunities Act a special law vis-a-vis Civil Procedure Law, a general law in designing international jurisdiction. They may coordinate in various manners. In designing the heads of international jurisdiction, the 2 laws share a lot of similarities with some difference. To a large extent, the Immunity Act can be said to address the subject matter jurisdiction of Chinese courts against the foreign state, while the Civil Procedure Law provides further specific jurisdiction and the venue rules. Therefore, further reliance on Civil Procedure Law for immunity exception cases is absolutely necessary. I will pass through these slides about the service of process. We can say the interactions may be needed between the 2 laws. Okay. I would like to come to my final comments. There must be a lot of issues relating to the coordination of China's Immunities Act and other laws such as Civil Procedure Law and other laws, and a lot of other issues such as the limitation period, where the Foreign States Act before January 1st, 2024 will be within the scope of the Immunities Act, determination of the substantive laws for claims against the foreign state, recognition and enforcement of foreign judgments concerning a foreign state. These all issues must be resolved in connection with other Chinese law. Because the Immunities Act alone cannot provide such answer. All these issues call for further research of Immunities Act in a coordinated manner. That's all. Thank you.